The Executive Council met last week and they approved on the progress on the two criminal bills. I'm joined today with Ronnie to discuss more about these two bills and what we should expect from them. Hello.
Hello.
So Ronnie, what are these two criminal bills about?
Well, Exco's have basically approved the next stage of a process of two bills that will provide effectively a new criminal code for the Falkland Islands. Basically, to tell you as far as possible what you can and can't do as a member of the public. It won't cover absolutely everything because road traffic is going to be freestanding. I think firearms is going to be freestanding, and there'll be various administrative offences. But that's the difference. Crimes, basically things that are bad in themselves, and the things that are only bad because the government's told you they're bad will still be where the other legislation is. At the moment, Falkland Islands law, we've all read front page of the Penguin News. Where the state of Falkland Islands law. At the moment, it's a big mishmash of some of our own legislation and legislation that was borrowed from the UK, and some of that's very, very old. The oldest criminal legislation that applies in the Falkland Islands at the moment goes back to 1351, and they weren't even passing laws in English in those days. They were still using Norman legal French. The situation is that we've got this mess, for want of a better word, and that's not a criticism of anyone. It's how it's built up over the years, and it's where we found ourselves. And the point is that actually a lot of people are saying, and a lot of people are doing things to actually get that sorted out. And it was felt that the most important thing, the Exco papers go back a couple of years, and the most important thing was going to be the criminal law and the criminal procedure, because that's something that affects the citizen most. What can they do? So they know what they can and can't do, and they know what will happen if they do it, and also the protection of society. So society knows that it's protected, and that if someone does break the law, something can be done about it. It's split into two, and as I say, I'm calling it the criminal code. That's not an official term, but it's really just there'll be one book that you'll be able to look in one place and be able to see. And it's split into two: a criminal law bill, which will deal with what is and what is not a crime, and a criminal procedure and evidence bill, which is what happens. And the beauty of the new bill is it's actually going to bring all of the old legislation from all of its sources into one place. And I understand, looking forward to seeing it, but I understand, I've had a sneak preview that it's going to actually be arranged in a much more logical order than at the moment. So it's actually the criminal procedure and evidence bill is actually going to start from the moment that someone's arrested or an investigation starts, and then trundle in order right through the investigation, the court procedure, sentencing powers of the court if someone's convicted, and ultimately in the end to the early release licensing provisions at the end of someone's sentence, and also some of the orders that apply to someone when they're back out in the streets. For example, sex offenders, things to protect the public even after they've been released. And so it's actually a really, really simple, very clever device that of actually arranging it in that chronological order. So actually, if you're saying it, if it's the start of the process, well, we'll look at the start of legislation. If it's towards the end of the process, then we'll look towards the end. And obviously, if it's in the middle of the process, you look somewhere near the middle. It sounds incredibly simple, but actually and it sounds incredibly obvious. But it's not how a lot of the law. Well, it's something you just can't do at the moment.
Okay, and what's going to happen next with those two bills?
Well, what's happened is that the process has been going on. We're coming up to the critical stage of a process that's been going on for 2 years. Exco originally commissioned the work. We're partly funded by FIG and partly funded by the Foreign Office. And they hired in an external drafter who'd done similar work for other overseas territories. He did St Helena's criminal code, Gibraltar's criminal code, and I think the Turks and Caicos Islands. So he's quite familiar with it, and he came down for an initial visit. Started up a process of gathering the information, meeting with the stakeholders. Alison Ingalls, who at that stage was in the AG chambers as well, did some of the initial work of drafts coming in from John Wilson, then being emailed around to the people who needed to, the people who knew about it basically, so that they could comment on it, and then feeding that back and another draft. A first draft of the whole thing was produced this time last year, And since then, it's been the second phase of producing the draft, and we've been very lucky. FIG was able to get someone on secondment from the UK Crown Prosecution Service, Gillian Curl, who's with us, and you probably might have seen her around. Certainly seen her in Bittersweet if you've been in there on a Friday evening. Sorry, Gillian. And she's a very experienced prosecution lawyer. She's been working with John Wilson, the external drafter, and they've now produced over 1,000 pages of draft legislation, which I am still looking forward to seeing, because although it's been approved, it's not yet been published. What will happen is it will be coming before the Legislative Assembly for what's called second reading at the end of August, and that's basically just, it will be a short debate about the principle, the idea of having a new criminal code. Once that happened, it will then go into committee, and it will trundle through committee during the month of September. There'll be, and what they'll do is actually say, right, we like the idea, we're actually going to go through it line by line, a bit like they did with the children, the recent children bill, and actually deciding whether or not about the detail, and actually scrutinising the detail of that. They'll produce a report saying, well, these are the changes we'd like to make. A.G. Chambers and John Wilson will actually make the amendments, and then in October probably there's going to be another marathon session of Legislative Assembly. A friend of mine described the last one, where they were doing the children bill, as a Legislative Assembly for the connoisseur, because only a connoisseur would enjoy it. This one's going to be for the super connoisseur. At that stage, there will be a debate on, let's say, on the Select Committee report, which will be, again, it's about the principles, the ideas, and then so they'll say, yes, we want to make changes about, say, vulnerable witness protection, or they want to, we think the time limits ought to be longer. Then they'll go into the committee stage, where they actually say, Clause 5 should stand part of the bill, and Clause 6 should be amended by changing 7 to 14, and going through that. But that's it sounds a painstaking process. It is a painstaking process because it's important to get it right. This is probably something that's going to be for a generation. It's not something that's, and it's not something we want to keep chopping and changing. It's not something anyone wants to keep chopping and changing. I said we are forgetting I'm not in A.G. Chambers anymore. The important thing is to get it right. So it is a painstaking process to get it right. So it won't make very good listening on FIRS, but it's absolutely vital. At the end of that, it will be published in the Gazette, and it will become the law of the land, and it will be backed up by training. It will be backed up by new procedural rules for the court. It will be backed up by internal procedures at the police and elsewhere. And legal practitioners like me, like my other professional colleagues, will be getting used to it on a day-to-day basis. For the public, there'll be a number of specific changes, and the most visible, although hopefully not to FITV's viewers on the whole. I don't think the target demographics gets arrested terribly often, but the caution will be changed. So it'll be a bit like the moment it's the old-fashioned caution. You do not have to say anything, but anything you do say will be taken down and maybe used in evidence against you. It will change to the longer one that you see in you used to see in the bill or other police dramas, Law and Order. That you don't have to say anything, but if you do not say something and later rely on the court, then I've now got a very bad policeman because I've forgotten the exact wording, but basically it includes the longer-winded. But the vital difference is that it's at the moment someone can actually go into the police station and say no comment, not answering, no comment, not answering, and that can't be none of that can be used. In the future, that would be if someone puts forward an explanation late in the day, the bit about the later rely on court, it may harm your defence. And if FITV ever does a new procedural drama, then you'll have to change the course and find ways of covering it up. I remember when it was introduced in the UK, the bill had terrible problems. They had to find ways of actually covering up this other, so they didn't lose half the programme when the suspect was being cautioned. And they got very good at it. The other main changes will include things like updating the law of fraud. At the moment, we've got the old technical deception offences, and they cause a lot of problems because they are technical. A classic example was that under the old law was, can you steal a megabyte? And the new law will be based on law that's come from the UK. It's been in place there for 8 years, works very, very well, and while it might be adapted for here, it'll be based on that. There'll also be things about protection of the community. There'll be things about protection for vulnerable witnesses, updating the provisions about a protection from sex offenders even after they've been released. And also there's talk of changes to the powers of the court in relation to community sentences. Again, borrowing and adapting ideas from the UK. To give the court more flexibility, at the moment there's actually a problem dealing with someone who's a repeat offender or someone who's done something that's in the middle range. It's more serious than a fine. Community service isn't just enough on its own, because there might be other issues like getting treatment or for alcoholism, or treatment for some other issues the person might have. But it's not appropriate to send them to prison either. And at the moment, we've got the old-fashioned and fairly basic community sentencing provisions. Bringing in additional provisions will actually allow the court to deal better in the interests of the community, and actually probably in the interests of someone who's before the court as well. So that's a flavour of the changes that are going to be in it. There's going to be a lot in it, and I'm looking forward to scrutinising it myself, and probably coming back with comments and saying, "Hey, have you read? Have you read?" So that's what it's all about, basically.
Thank you so much, Ronnie.
No problem. Pleasure.
Still to come.